of the current monthly salary of the office holder. 6. Full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7. 2 drivers. 8. 1 personal assistant. 9. 1 accountant. 10. 1 secretary. 11. 2 housekeepers. 12. 2 senior support staff. 13. 2 cooks. 14. 2 gardeners. 15. 2 cleaners. 16. Armed security guards, who shall be provided on the request of the first petitioner. 17. Diplomatic passport for the first petitioner and his spouse. And 18. Office and office equipment. 19. Maintenance expense for the vehicles provided. 20. Access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Ms. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for cost determination. 1. Whether the National Assembly motion met the constitutional threshold under Article 145. 2. Whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3. Whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D. Whether there was adequate public participation at both the National Assembly and the Senate. E. Whether the speakers of the National Assembly and Senate were biased in reality or in perception. F. Whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G. Whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then, lastly, what are the available reliefs? They collectively, the lawyers for His Excellency, the petitioner Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Council noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Council drew the support from the cases of Mike Sonko, which we have, particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ngoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondent's invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submission, His Excellency Gachagua specifically impugned ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Kariuki versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the Decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submission, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, Sub-Article 3B, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities, including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonas drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachagua drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Imanyara and 2 others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June, 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Jerry Maina, the third petitioner in the consolidated petition, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as and in public interest. Her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27, 81B, 102, 161 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in their in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional